All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the first webinar of our 2025 Education Law Series. Today's webinar is Educational Advocacy, Health, and Educational Options. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. The training is being recorded. If you're registered for this training, you're going to receive a copy of this link. I will also drop my email into the chat just in case you need access to the recording and the materials. The training was approved by the Florida Bar for 1.5 general CLE credits, 1.5 certification credits for both education law and for health law. I'll announce the CLE code towards the end of the session. I will also drop it into the chat as well. And the CLE code will also be included in the email that goes out from Zoom. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. This training is also being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to drop their link into the chat as well so you can familiarize yourself with the section. And final piece of housekeeping announcements are questions. If you do have questions, please try to use the Q&A feature on Zoom. You can even post questions anonymously. Since we have a lot of content, we're going to try to address all these questions towards the end. But if you do have questions, don't hesitate to ask. Use that feature, and we'll do our best to address every single question toward the end. So I'm going to go ahead and introduce our speakers today. Our first speaker is Beverly Brown. Dr. Beverly Brown is a passionate legal advocate and lifelong educator with extensive experience in educational advocacy and Social Security appeals for children with disabilities. A former Equal Justice Works Fellow at Three Rivers Legal Services, Beverly has represented students in due process, Section 504, and ADA matters across 17 Florida counties. She now provides pro bono services through Southern Legal Counsel. Beverly has also a rich background in teaching and program development and remains committed to empowering children through individualized advocacy. Our other speaker is Glorian Maziarka from Comeria, Puerto Rico. I was definitely going to say that. She knew I was going to say that. Glorian is my colleague and an attorney with Florida Legal Services Children's Health Access Project. She focuses on expanding healthcare access for children and guiding families through transitions such as guardian advocacy. A graduate of University of Puerto Rico and St. Thomas University School of Law, Glorian brings broad legal experience in both public interest and private practice. Her advocacy began in Palm Beach County, working with homeless and mentally ill populations. So, without my further ado, it is my pleasure to pass it on to our speakers today. Glorian, I'm going to pass it off to you first.
Thank you, Jorge, for that introduction, and good afternoon to all our viewers today, and thank you for attending this program. Again, my name is Glorian Maziarka. I'm an attorney at Florida Legal Services Children Health Access Project. Our project is dedicated to address healthcare barriers for children in all counties in the state of Florida. And I am very honored today to be presenting here today with Beverly Brown. She's an attorney that I wholeheartedly admire, and I am so happy that she's was able to do this today for the Florida legal community. And today we're going to discuss health and educational advocacy for children in Florida and how these two areas interconnect and have a symbiotic relationship where they affect each other. Health advocacy involves advocacy to ensure children have access to healthcare, as this can affect many areas of a child's life, including education. Health and education have, a symbiotic relationship where they both interact and affect each other. You could get a case, for example, where on its face it just looks like a child needs educational advocacy. However, the child could have health or related issues that are underlying, that are causing these educational issues. In turn, these could be because the child has an undiagnosed condition, for example, or has been denied a needed service by a healthcare provider or by the health insurance, or simply the child doesn't have health insurance. For this, they're going to need health advocacy. I'm going to briefly discuss social determinants of health, which addresses areas in a child's social life that affect their health, as well as the importance of healthcare access for children. I will give a quick snapshot of the Florida Kid Care system for families with low income children. And finally, I will discuss how healthcare coverage has an impact on a child's education and school-based services available in Florida. So this slide, we're going to discuss the social determinants of health. There's a wide variety of CLEs that discuss this topic. And the social determinants of health refers to those components in your life that affect your health. The World Health Organization, the WHO, defines the social determinants of health as the conditions in which people are born, grow, live, work, and age, shaped by the distribution of money, power, and resources at all levels. All those factors have an impact on a child's life and their health. And addressing those social determinants of health improves a child's well-being and reduces health disparities among different economic social levels. This is where legal aid organizations can step in to address those other issues that may affect healthcare. And legal advocacy is invaluable to address housing insecurity, for example, access to public benefits such as food stamps, WIC, TANF, to address food insecurity, family advocacy to address issues affecting the child's family environment. In this next slide just talks about the examples. For example, educational opportunities available to a child, such as good early childhood education, a child's social environment, for example, during growth and development includes their experiences within their family and community, their inclusion in the community, available social assistance, and access to recreational and leisure activities. Food insecurity can also affect a child's life, including their access to nutritious food. Housing insecurity can affect a child's health, including their mental health. Safety of their housing can also be a concern. For example, exposure to mold in unsafe and unsafe housing conditions. A child's environment can also have a significant effect on their health. Issues such as the prevalence of crime in their neighborhoods and their exposure to violent behavior can affect a child's mental health. There are also physical effects to a child's health where there are environmental concerns such as air pollution and contaminated water. Finally, a child's access to health coverage and access to providers has a huge impact on a child's overall health. This is especially an issue for minority and immigrant children, which have more issues accessing health coverage, and children in rural communities, which may experience a shortage in health providers where they live. There are many great resources in this website, and I included the link here. Healthy People 2030. This is a national public health initiative released every 10 years by the Department of Health and Human Services. And they identify science-based objectives and set targets on nationwide health priorities. And this website has a huge bank of information regarding health in the United States. I encourage you definitely to go check it out. Next slide, please. All right, so here what we talk about this symbiotic relationship between education and health. Education as a determinant of health outcomes. Education is a key factor in improving the health of children and later adults. A child who is well educated on health factors makes better informed healthcare decisions and is better equipped to navigate healthcare systems when they become adults. Higher education levels lead to better job opportunities, higher incomes, and improved access to healthcare. Educated individuals tend to adopt healthier lifestyles and reducing their risk of chronic diseases when they're adults. Now, on the other turn, health is a determinant of educational outcomes because issues at school may be due to health issues, and poor health issues often results in poor academic performance, lack of participation in school activities, as well as higher probability of school failure, grade retention, and dropout. A good example of how health can affect educational outcomes is the Flint water crisis. I'm sure that most people have heard about that. In 2016, it came to light that the residents of Flint, Michigan were exposed to high levels of lead in their water supply. And there was a study that was supported by the National Science Foundation Graduate Research Fellowship Program that found that the substantial negative effects of the Flint water crisis on the academic outcomes of children living in Flint. And this study discussed other research that found that Flint children were found to have higher levels of lead in their blood, which this was associated to a host of other problems that increased behavioral problems, anxiety, decreased academic achievement, decreased brain volume, and higher risk of criminal offending. I can actually drop this on the folder that Jorge will make available. But this was a study by Trejo, Yeomans, Maldonado, and Jacob. It was titled "The Effects of the Flint Water Crisis on the Educational Outcomes of School-Aged Children." So this is just how the environment and health issues can affect educational performance. Next slide. Right, the importance of healthcare access. If a child has problems accessing healthcare to address their issues, this will have an impact on their education. An example of this is a child with behavioral issues who does not have access to proper therapy, or a child with a chronic health condition that does not have access to the prescription that they need or the healthcare that they need. These barriers are most common in low-income and minority communities, especially American Indians, Alaskan Natives, and Hispanic and Latino communities. Georgetown University has ranked Florida in the bottom 5 of all states in the United States in the terms of uninsured children. In Florida, an average of 7.5% of children do not have health insurance. Currently, a little over 9% of all children eligible for Medicaid in Florida are not participating in the program. As we can see, the lack of access of healthcare leads to lower educational outcomes, and the cycle just keeps repeating. Therefore, access to low-cost healthcare can greatly improve a child's overall health and education. And I'm going to be dropping this link on the chat for everybody's view, which Georgetown does have a lot of good resources when it comes to all the states, when it comes to healthcare coverage. Next slide. All right, so this is a quick overview. We're going to be doing a CLE later on that will discuss more in depth all the different programs of Medicaid and go to the nitty gritty, because Medicaid is a whole world. So we're not going to go in depth into it, but this is just a quick overview. Healthcare programs in Florida for low-income families with children the whole program is called Florida Kid Care. So this is divided into the 4 categories. Medicaid, which the most common group is the children from 0 to 19. This is your no-cost Medicaid, which is the most robust type of healthcare for low-income families in Florida. This is no premium cost for families who qualify. There's a bunch of other categories, again, that we'll discuss at a later time. The next one will be Medikids. The rest of the others are more the CHIP subsidized options. This is for people who do not qualify for Medicaid because they earn too much money. So whenever they cannot qualify for Medicaid, we would try to qualify them into these programs if they are within the income limits. So Medicaid will be for children ages from 1 to 5. With the CHIP option, their premiums will be anywhere from $15 to $20 a month. And if they don't qualify for the CHIP subsidized option, there is a full pay option, which is $248.21 a month. And then there's the Florida Healthy Kids, which is ages 5 to 19. Same premium, $15 to $20 a month, with the full pay being $259.50 a month. And then you have your CMS, which is the Children Medical Services for children 0 to 19 or 21, and they must have special needs, special medical needs in order to qualify for this specific program. There is a CHIP subsidized option, but there is no full pay option for this program. Next slide. All right, so how can health coverage help your child's education? So early detection of physical or mental disabilities could be detected, if you cooperate with the school professionals and the parents and the child's medical providers. In the case of children with IEPs, it's very important that the parents understand the IEPs, read the IEPs, work with the professionals and understand the recommendations for those IEPs and how to utilize the plan's therapy and related services to improve that child's progress. And it's important that if the child is on Medicaid, for example, that the plans that are available in Florida, all the plans could be Simply Healthcare or Sunshine Health, Humana, all of those different plans in Florida. They offer expanded benefits. A lot of people don't know about them, but expanded benefits is in their member handbook. They offer a lot of benefits that could benefit your child, and including behavioral type of therapies and all kinds of different, even swimming lessons, gym memberships, a lot of things that can benefit the child. It's important that they look into those expanded benefits. Next slide. All right, so another thing is that we'll talk briefly about is the school-based health services. So all the schools in Florida have health services, and they are categorized in three types. There's your basic school health services, your comprehensive school health services, and your full service schools. So the school-based services, they're all regulated by different statutes. I included the statutes in there so you can read more comprehensively as to what they include. And next slide. Right, so basic school health services. So these are provided in all of Florida's 67 counties. These include your nursing assessments, health counseling, referrals and follow-up on health problems, individualized healthcare plan development, and many other services that addresses day-to-day student health needs. Next slide. All right, comprehensive school health services. These are provided in 46 counties, and these are locally selected schools with high rates of teen birth, substance abuse, and other high-risk behaviors. And these include all the basic school services, and they provide increased services, which address high-risk behaviors like substance abuse and sexually transmitted diseases. They provide services for pregnancy prevention, intervention, and support services after giving birth. Next slide. And finally, you have your full service schools. They are provided in 66 counties in the schools with high number of medically underserved high-risk students. These include all the basic school services and the following school-based health and social services, which are nutritional services, economic and job placement services, parenting classes, counseling for abused children, mental health and substance abuse counseling, and adult education for parents. I personally have visited some of these full service schools, and they're amazing. Some even have closets for children whose families need clothes. Is incredible. And one of the things I've actually talked to some of the schools and the Department of Health, and it seems that if you want to know more about what services are provided, I'm sorry, next slide, Jorge. Yes, if you want to know about which ones is offered in the school, the county health department, they manage the local school health program, and they just collaborate with the school district. And the local health program has their own services and the resources they offer, and they may not be offered in other counties. So one county may use a certain health curriculum, and another county may have agreements with hospitals or health providers, and they may refer the students if they cannot do it in the school. So if you want to know more about what your school can do, just refer to the local county health department and ask them what local services they have to offer. I believe that's my last slide, correct, Jorge? Oh, yes, no, this is my last slide. So Children's Health Access Project of Florida Legal Services. I just wanted to let you know a little bit of what we do. We have a team of outreach and enrollment specialists that assist families and with children and pregnant women to apply and renew for Medicaid and Florida Kid Care plans, which are the subsidized options. And the attorneys, we assist with the healthcare barriers on all the above, including grievances and appeals to DCF for denials of Medicaid, or also with ACA for denials of services. So that concludes my presentation. So I'm going to pass it on to Beverly.
Thank you, Glorian. That was awesome. A lot of great information. I know everybody's going to appreciate having access to that. We're going to talk about educational advocacy, and I'm going to try to speak up. I've been told that I sound kind of muffled, so if you can't hear me, let Jorge know, but I'm trying to project. What I hope to go through is the controlling law in ESE. In Florida, it's called exceptional student education. In the rest of the United States, it's referred to as special education. How advocacy is different from legal work in general, what testing and eligibility looks like, the response to intervention multi-tiered system of supports, 504 plans, IEPs, functional behavior assessment and behavior intervention plans, briefly what the matrix is, and then what happens if it all falls off the shelf and there's a dispute. So what does that look like? Next slide. The controlling law for special education, the primary statute is referred to as IDEA, which is 20 U.S.C. 1400. The federal regulations, Chapter 34, Sections 300 are the regulations that apply. Florida Administrative Code, Chapter 6A, then breaks down all kinds of other things that you need to know, specifically the precise things that students need to have for eligibility for specific categories in ESE in Florida. And then the controlling Supreme Court law and what is a free and appropriate public education was for many, many years the case referred to as Rowley, Hendrick Hudson versus Rowley, and the case Andrew versus Douglas has expanded that Rowley case a bit. So we'll talk about the Supreme Court law in a minute. Next slide. The historical development of IDEA, originally it was in 1975, it was developed as the Education for All Handicapped Children's Act, and it was Public Law 94-142. The Supreme Court cases and these district cases kind of laid the groundwork for this development. So Brown, which we're all familiar with, integration in schools. We're now looking at education for people who have unique learning needs, not just people of different races. And then the Mills case is a class action that established the right of students to a free public education if they had disabilities. And then the Pennsylvania art case was a case that said if students had intellectual disabilities, that they had a right to public education. So all of these cases were decided prior to Congress saying, it looks like we need to provide access for all of these students with unique needs in public education. Next slide. Then once the Education for All Handicapped Children's Act was passed in 1975, the Supreme Court refined how things were interpreted with these different cases. So the Rowley case, as I stated, established that there had to be some educational benefit for students in their educational placement, but that for a free and appropriate, which we call FAPE, free and appropriate public education to occur, it just needed to rise to a basic floor of opportunity for students in ESE. So we weren't aiming for the stars here. It was a very low bar, and it was considered pretty bad case law for those of us who were advocating for a long time. More recently, the Andrew v. Douglas case established that for it to be considered adequate progress for a child in an ESE classroom, they have to make progress in light of that child's circumstances. So it's expanded the Raleigh case a bit, not greatly, but some. The Burlington case stands for providing reimbursement for parents who take their child out of a public setting and place them in a private setting when the public setting doesn't have an adequate education for them. So in this case, the IEP was inappropriate, and the parents put their child in private school, and the court ruled that the private school was more appropriate, and therefore the parents had to be reimbursed for that private setting. The Honig case stands for what we call stay put. So if a student is in a behavioral situation, they're at a fight or they're being recommended for expulsion, they've had more than 10 days of out of school suspension, you cannot remove them from their current placement if they are in ESE until there has been a manifestation review of their disabling condition. We'll talk a little bit more about that going forward. So just kind of hold that in your head. TATRO stands for the Related Services Provision interpretation in IDEA. So if a student needs additional services to be able to access their education, in TATRO, this student had to have a clean intermittent catheterization done throughout the day to access his education, and in order for the student to receive educational benefit, and the court ruled that that had to occur. Similarly, Garrett was also a related services case, and Schaefer v. Weiss is a case that determined that the burden of persuasion is on the party seeking relief in ESE cases. Draper is an 11th Circuit case that determined that when students are denied FAPE, compensatory awards needs to place that child in the situation that they should have been in, but for denying them those services. So that's just kind of a real brief summary of the case law that guides us in this area. Okay, next slide, please. IDEA is divided into 4 parts. The first part is the definitions that guide us in the statute. The part B is a major part of the act, which guides us from the age of 3 to the age of the 22nd birthday in Florida, that covers the majority of education for students in public ed. Then part C is for infants and toddlers, and part D covers grants and technology and training. Next slide. In this area of law is different than a lot of areas because you are working within a school system. So if you haven't worked within schools before with students who have unique needs, you're working with a team. Typically, the attorneys, not always, but oftentimes are kind of team players. They, you are working on behalf of children, and it's an awful thought to think that you would be working against those child's needs. Now, that some cases are that way, and you have attorneys who can be contentious, but a lot of times everybody's trying to work toward a win-win. The parents don't always realize it, but they have extreme power in this field. They have the right to request many things, and it helps that you can help them understand that. It helps to plan ahead and be knowledgeable about all of the students' records. But while you're doing this, preserve evidence in case things don't go well, and come into all of the meetings that you might likely have with some sort of alternative plan. So come to the table with more than just one idea, because sometimes it takes creativity to make things work. Next slide, please. So you come to these meetings typically that schools have with a concern about students' performance. And there are two ways this might happen. You might have a parent who's very concerned, and the parent might request an evaluation. If that happens, you want the parent to request the evaluation to be concurrent with what they used to call response to intervention. Now they're calling it multi-tiered systems of support, or MTSS. So either RTI or MTSS needs to be requested while the evaluation is conducted. The school has 60 school days to complete the evaluation in all areas of suspected eligibility, and then a meeting is conducted where it's reviewed and eligibility determination is made. Either it's yes and an IEP is drafted, or no and maybe a 504 plan is drafted, or no services. Or you come at this another way, where the teachers are seeing the student struggle and they apply the tiers of intervention through response to intervention, RTI, or multi-tiered systems of support. And they've done this multiple times and it's not working. And when it's not working, then they reach out, or arguably should be reaching out to the parent for request for evaluation. And at that point, it starts the process of, they have 60 days to complete the evaluation in the suspected area of disability. And then once it's done, an eligibility determination meeting is held. Okay, next slide. So the response to intervention multi-tiered systems of support is required for all school children. So everybody is on tier 1. That's just instruction that's happening in the classroom. If someone is struggling with instruction, then either more instruction is given, so the intensity or the nature of that instruction is changed to a certain degree. That's tier 2. And then sometimes a different method of instruction is changed for tier 3 if they need something else. And that's what it looks like with response to intervention and multi-tiered systems of support. I have theory versus practice, because in theory, every student who's struggling should be getting this in TSS throughout their school years, every year. Even students who have IEPs should be getting MTSS. But it's not always happening, and it's not always happening in a way that is beneficial for the student to make the progress that they need to make. When you, next slide, please. When you are involved with schools, it's a bit confusing, because not only is it an alphabet soup of things that can occur, but there are multiple meetings. So on the next slide, you'll see all of the possible meetings that can occur. So this RTI MTSS that I just talked about is one of the possible meetings. You can have an eligibility meeting, which is when, all of the things would be ticked on the Florida Administrative Code for that area of eligibility, or not. And you would then have an IEP drafted. There's eligibility step and an IEP step. The IEP is an individualized educational plan that is developed by a team for that particular eligibility category. And we'll go over what categories are eligible in a minute. 504 plan is a of an IEP. The functional behavior assessment would be collection of data for a student who has some pretty severe behaviors. And that kind of data would be collected under the RTI MTSS process also. And then the behavior intervention plan would be drafted. That could be drafted under the RTI MTSS, also under the FBA process. And then you may have a safety plan drafted. So at this day and age, you can have a student with an IEP, a 504 plan, a safety plan, an FBA, and a BIP. So it gets very confusing sometimes which meeting you're being invited to and what you're actually working on. But they all have their purpose and they all are effective if used appropriately. Next slide, please. So Section 504 is Section 504 of the Rehabilitation Act, 20 USC 701B1, and it is empowering individuals with disabilities to maximize their situation, employment, independence in society, etc. So in school, you're typically dealing with the individual's ability to deal with school, with learning and adapting to the environment in a school and being able to access curriculum in the school, etc. So it's a series of accommodations that allow that individual to be successful in the school environment. Under IDEA, you have rights and benefits that are protecting a student and allowing them to have a free and appropriate public education through the IEP and procedural safeguards. So IDEA is a much more robust and supportive statute than 504. 504 would be for someone who didn't need as many supports. So when Glorian was talking about somebody with healthcare needs, if somebody needed just accommodations to access the school environment, then a 504 might be wholly appropriate. But if somebody needed some kind of specialized instruction in multiple areas and accommodations, then you have students who are eligible under autism spectrum disorder, and that's a continuum. So you have students who are very bright who are eligible as ASD, or you have students who are on the lower end cognitively who can be eligible as ASD. You have students who are deaf or hard of hearing. You have students who are developmentally delayed, and this says pre-kindergarten only. That is not accurate anymore. Students who are developmentally delayed now until age 9. So the time when they would be reevaluated would be before their 9th birthday to determine if they still had a developmental delay, which is much more appropriate than in kindergarten. You have dual sensory impairment. They might have deafness and blindness. You have emotional behavioral disabilities, which would rule out other things like autism or learning disabilities and show that the behavioral is the predominant area, or emotional needs are predominantly what the child is struggling with. Gifted is also served under ESE. So gifted would be a student whose IQ is 2 standard deviations above the mean. You have students with intellectual disabilities. That would be somebody with an IQ 2 standard deviations below the mean. You have situations where students might be homebound or hospitalized. They require an IEP. Those might be short-term or long-term placements. So you might have a student who has some severe health needs or some short-term health needs, can't come to school because of those health needs at this point in time, is in the hospital or needs to be at home, and that requires a different IEP. So that's called a hospital homebound IEP. Students who have physical impairments with orthopedic needs would qualify for one category, or a student who is physically impaired with health impairment would be another category. So other health impaired is the category. That would be somebody who has healthcare needs that exceed a 504 accommodation. So somebody with severe allergies or ADHD or something that requires an instructional program and services would fall under other health impaired. Sometimes students on the autism spectrum get identified as other health impaired because they haven't been determined to be on the spectrum yet. Students with specific learning disabilities, they have to go through quite a bit of response to intervention because the reasons response to intervention MTSS was developed was because specific learning disabilities had been a category that Congress thought, well, everyone thought that was being over identified. And so the reason that RTI MTSS was developed was to look at everyone and make sure we weren't over identifying students as learning disabled. And so we are now giving students more opportunities to learn through RTI and MTSS, and arguably students who have learning disabilities or speech impairment, they should have an opportunity to go through multiple iterations and reiterations of the curriculum and would be able to learn the material without being identified. If they haven't learned it, once they've gone through the 3 stages of RTI and MTSS, then they need to be tested to see if indeed they have learning disabilities or language impairments. So those are all of the categories that are eligible for ESE under IDEA. When you have an IEP, there's a certain statutory list of people that have to be present. So it's not considered a valid IEP unless these people are invited. So always a regular teacher of the student or a regular teacher of the student's grade, if the student hasn't been at that school, needs to be included. The parents need to be included. A special education teacher needs to be included. Somebody from the school district who can, who's knowledgeable about the programs in that school. Somebody who can interpret instructional data or testing needs to be there. And if any other program supports, for example, if a student is orthopedically impaired or has speech and language needs, or these people need to be involved in the meeting as well. The student can also participate in the meeting. By the time they're 14, they are invited to the meeting, and then for the rest of their education are invited to the meeting. But if the parents want them to participate before they're 14, that's fine. So students should participate when it's appropriate, and it's a good experience for them, particularly if they've been trained somewhat to participate or allowed to have some self-advocacy instruction so that they can advocate on their own behalf. And if there are other agencies involved with the student at all, like APD or any other agency, if there, juvenile agencies involved or whoever, the parent can bring anybody they want legally. And that's always nice for the parent to know. A lot of times, if it's a contentious meeting, the school will have many, many people there. And if it's just the parent or the parent and the parent's advocate or the parent and the parent's attorney, it can be kind of daunting for that parent to have to sit in a room with 16 or 20 people at the table and feel like they're outnumbered. So it's important for the parent to bring providers that they know will be in support of what that student needs. And if they can't bring the provider, bring letters from the doctors or paperwork from that provider. Sometimes providers appear through Zoom, sometimes they appear on the phone. It's just important for the parent to know that they have that right to bring whoever they can and want to bring. So then what is this IEP? The IEP is a prescription of the individual needs of this particular child. And it can be rewritten as many times as needed, and sometimes it's many, many times. At a minimum, it's once a year. So annually, every year, the IEP is drafted. It includes the child's present level of performance, which is affectionately called the plot of the child. It includes the effect of the child's disability on, how does this child's disability affect their educational performance? There are annual goals established and objectives to meet those goals. So how are we going to measure this? And where are we hoping this child will end up by the end of this year? There's a statement of the degree that the child will be placed in any special education and related services. There's an explanation of the extent that the child is going to be placed with non-disabled peers in the regular classroom. And that's very important, that a child is placed to the extent possible with their general education peers. There's a projected date when the services will start, and then there's an anticipated frequency, location, and duration. So all those things have to be on this document. Where are the services going to happen? When are they going to happen? How long will they be each day? And anything else that is important about these particular services. The services on the IEP are divided into domains. So each IEP would have 5 different domains. And not all children will have services in each of the domains, but there are 5 areas that a child may receive services in. So curriculum and instruction, which is just what it sounds like. The child has learning needs in math or reading or science or spelling. Those are curriculum and instruction needs. That's the domain of service that they would be receiving services in. If the child has issues with relating to other students, with social ability, with anything that's emotional in nature or behavioral, then that would be a domain that the child needs supports in. If there are toileting needs or feeding needs or walking, transferring needs, all of those things, independent functioning would be the domain that the services would fall in. And frequently you see occupational therapy in that area. if the child has an illness that needs to be addressed at school, like the child in Tatro with the clean intermittent catheterization issue, that would be a healthcare need, or those students who have a daily insulin need, that's healthcare. That would be an area of service provision. And then students who have language impairments or articulation issues, speech and language needs, or students who have frequently students on the autism spectrum that have communication issues. So these are the 5 areas that services are provided, and services are divided into these areas and addressed with goals. And then services are funded in these areas on a matrix, which I'm going to briefly go over. We don't have a lot of time to calculate it, but we'll talk about it. It's a funding mechanism. Okay. So how does service look? More and more you see everybody in gen ed, which is a great thing. I started teaching a long time ago, back in the 80s. And when I first started teaching, I was a proponent to put everybody in gen ed, but that everybody was not in gen ed in Florida. Most of the students that I worked with were separated from the general education population, and they were what you would consider mildly disabled students. So they had mild behavioral issues or mild learning issues. Nobody was 2 standard deviations below the mean in any way, shape, or form. So a lot of these models where students are pulled out into another setting were very popular, and teachers were teaching in these separate settings. That doesn't exist as much now. And the model of school is all over the place these days because we have so many virtual options, a lot of homeschooling going on, many charter schools in Florida, many private schools in Florida. But the models that exist in public school for students who have special needs are primarily students are educated in gen ed with an IEP when they have lesser needs. And if they have very low needs, I would say that they need very little service at all. That's called consultation. So when you see a consultation IEP, that's when the instructor is talking to their teachers. There's really no service directly provided to the student in those cases. And usually they're working their way out of the special ed environment altogether. They may just need, a 504 with some accommodations, or they may be keeping the IEP with the accommodations and consultation, but they're not receiving services anymore. Sometimes they have pull out for a specific subject, like reading. If a student needs assistance with reading or math or some specific subject, they have what they call a pull-out situation. Sometimes they do speech and language like that, occupational therapy like that, some of the supports that are not traditional classroom subjects. Support facilitation is a very popular method of service option, popular service option method. It's when a teacher moves into a classroom, an ESC teacher moves into a gen ed classroom and supports those students who have unique learning needs in that classroom. So the teacher is wandering around kind of like a paraprofessional, assisting with this and assisting with that. The students may not know who the teacher's working with. It's not like the teacher has a specific list and is only working with those students. The teacher can assist anyone that needs help in the class, and it provides support for that gen ed teacher and the students with IEPs. Sometimes in a really great setting, you have an ESE teacher paired with a gen ed teacher, and that's a co-teaching environment. And those are wonderful, but rare just because it's difficult to serve all the students who are in need with co-teaching due to scheduling frequently. And the resource room would be when, for a period of time, students are removed for that whole entire period. So you see this a lot with learning strategies class in Florida, with speech and language course in Florida, something of that nature. It could be a reading block, etc. A self-contained environment is when you have the students removed for the better part of the day. And they have some schools that are like that, where students have behavior that can't be integrated into a gen ed environment, so they are removed for the entire day, and they're in a separate wing of the school, or they may have language needs and they're removed for the entire day, or they may have cognitive needs and they're removed so that's considered self-contained. We've talked a little bit about hospital homebound. That would be when they can't be at school. So hospital homebound, you need to have doctor's permission, and it can be a long-term or short-term depending upon what the student's needs are and how long the doctor has requested it, and whether the school is accepting the doctor's request or not. ESY stands for extended school year, and right now in a lot of counties we're getting ready for that. Extended school year is when the student the student is likely to regress over the summer because of the needs that aren't being met, and so they provide them with ESE or special ed summer school, and so those needs are met for a month or more throughout the summer. And then related services are those services like the clean intermittent catheterization, or like speech and language, or like occupational therapy, that students need in order to access the curriculum. So they might need transportation to access the curriculum. They might need this speech and language in order to access the curriculum, whatever it is that they have to have in order to be able to get access to the classes that students who already have access have. We now have in Florida this scholarship opportunity called the Family Empowerment Scholarship. So any student who has a disabling condition, or any student who is Title I, or who would qualify for Step Up for Students Scholarship in the past, would be entitled to this Family Empowerment Scholarship. And the matrix, which is the funding mechanism calculus, which is based on the 5 domains that I mentioned earlier: the curriculum, healthcare, social, behavior, and communication, funds that. So students who have high level needs get a high level matrix and have more funding. Students with lower level needs get a lower level matrix score and have lower level funding. That funding can be used with homeschooling and with private school funding for students who are not in the public school system. So you also have virtual school, and there are a variety of those options now. I don't have any idea how many options there are. There are usually some district-specific virtual options. There's a Florida virtual options with Florida Virtual School, and there are some private virtual schools. And each county has a different charter school policy. So some counties have many charters, and some counties have very few. Some counties have many private schools, and some counties have few. But those are the options for our students with unique needs nowadays, and there are quite a few. All right, moving on. So with students, there are several things that students who have unique needs, you need to be aware of several things. There are certain diploma options that you are faced with. So if you're working with older students, they have diploma options that are special diploma, and they have general diploma options. So students have standard diplomas and special diplomas. Option one under a special diploma is that they earn credits and master sunshine standards. So that would be students who graduate with a regular diploma, with a general diploma would be to earn credits and master sunshine standards, just like everyone else. And then option two would be vocational and employment skills. So that would be a special ed diploma that did not require mastering sunshine standards, and it would be a bit of a lower level diploma. You have students who are on what they call regular standards and students who are on access points. So in Florida, if you have students who are struggling and have IQs that are several standard deviations below the mean, and they aren't able to master these regular standards and earn the Sunshine State credits that are required for regular standards, they can be placed on access points. Students on access points can then work toward vocational and employment skills or life skills. But that is a decision that has to be made by the parent, has to be signed off on, and it's not something that the school can decide without parental input. So this is something that's important for everyone to be involved, everyone in the team to be involved with, and it's something that needs to be thought through probably when the child is very young. So you don't want to put the child on access points when the child is young and find out later that they want to switch off of access points, because that can be very difficult. So it's not a decision that's made lightly. And there's a lot of angst over making the decision sometimes, because it's difficult to know what the right decision is if you are dealing with someone who's kind of a borderline case. You're dealing with somebody who's really struggling, making headway with an option one diploma where they have to master Sunshine State standards, but they're mastering them very slowly, and it doesn't appear that they're making much headway. Another thing that you're going to have to be dealing with IEPs that as an attorney you might not have dealt with much as creating goals, and advocates a lot of times are quite good at this. Advocates who are educational advocates who may not be attorneys, they're familiar with goal setting and how they should be written. I have a little book that I've referred to. It's called From Gobbledygook to Clearly Written Annual IEP Goals by Barbara Bateman. She's an attorney and a Ph.D. It's a very, very short little book that gives examples of measurable goals and what's not measurable, and how goals can be written that make absolutely no sense at all. And that's part of the problem with some of the goal writing, is that they sound kind of impressive, but if you break them down, it doesn't really tell you what's being measured or when or who is doing the what. So it's a lot of verbiage, but not very effective as far as goal writing. So goal writing can be very important in the IEP process, and it's important if you have someone to assist you with that. If you're not familiar with it, you might want to practice. Some of the meetings that you're going to have do involve behaviors, and some of the meetings as attorneys that you get involved with are suspension and expulsion meetings. Students are being put out of school for a period of time, and if students have an IEP, this type meeting, this manifestation determination meeting, has to occur before they can determine if a student is able to be expelled or not. So if you're an attorney and you're representing a student in an expulsion hearing in front of the school expulsion process, it's a quasi-judicial process. It's very difficult to go through. It's I don't even know how to prepare you for that. The manifestation has to happen though before that process, and the quasi-judicial process is frequently not fair to the student, and if this manifestation process comes out where the child has a disability and you feel that, or you know for factually that the disability, the behavior is a manifestation of that child's disability, then you can challenge the whole expulsion. So how does that look? So what you end up doing is you have a manifestation meeting, and let me give you an example. The child has threatened to shoot someone, which seems to be a common thing for children to do at the middle school age, who are ADHD, and they have poor impulse control. And so this child has threatened to do this, threatened to shoot someone, but didn't have the means to do it, and was said in a kind of a social situation, and the child was awkward in this situation, and the child is known to be impulsive and says outlandish things, and you have proof of that, and you have some sort of forensic evaluation of the child to indicate that the child had no intention of doing anything like this. You can challenge the manifestation in front of an administrative law judge and in a division of administrative hearings hearing. It's that they have to have within 10 days of the meeting, the manifestation meeting, and the judge will determine whether it is a manifestation or not. If it is a manifestation of the child's disability, they have to put the child back in the school setting. And frequently, if it has taken a while for this to happen, even though it's supposed to happen within 10 days, then compensatory services will be ordered. So that means that you would get services for the child that the child has missed. So there is a remedy, even though sometimes these expulsion hearings can be unfair for the child. Okay, moving on to the next slide. I mentioned the matrix, the funding mechanism. You can pull up the matrix if it's available on the Department of Education, Florida Department of Education website. And it has all of the areas of eligibility on it, all of the areas of all of the domains that the child is covered in, and it breaks it down into a point system. And you can actually figure out how to calculate your child's matrix. It just has statements like requires specialized training in self-advocacy and understanding of their exceptionality, or requires small group training and social skills. So it has statements about what level of service the child would require. And if you check off the level that the highest level the child requires, then that is the level of service that that child would qualify for. And that's how you figure out the funding mechanism for that particular child. If anybody is interested in seeing a copy of the matrix, I can upload it after the presentation. It's something that is kind of unique, and as an attorney working with a parent in this area of law, sometimes the parents come to you just trying to get a higher matrix level. Why would that be? Because it funds the private school setting, and sometimes they just need more money in that area, and sometimes the school has missed something. I mean, you can't make up a higher area, but sometimes there is a need that has been missed. So I'll be happy to upload that later. All right, moving on, because this is not, we don't have time to talk too much about the matrix today. So with the IEP and special education, the area that is promised or is pledged is faith. So what we're proposing for students with unique needs is a free and appropriate public education for children who are 3 to their 22nd birthday in Florida. And that would be educational instruction specifically designed to meet their unique needs of the child with a disability, supported by such services as are necessary to permit the child to benefit from the instruction. And as the Andrew v. Douglas case pointed out, not only benefit from this instruction, but benefit in that child's special circumstances. So what you're looking at is a basic floor of opportunity with Rally, and they don't require that the child, you have parents that are looking for the child to make maximum benefit. I want my child to do the best that he can, and the school is not required to do what is absolutely best for the child, that they're required to make sure the child makes more than de minimis benefit. So the child has to make benefit from the instruction based on that child's needs. So if the child can make benefit, then we're expecting benefit, and everybody needs to make some benefit and have some growth. And a Cadillac and a skateboard, with the Civic being the floor of opportunity. I think we're still dealing with educational benefit and making progress, but like I said, with Andrew, we're dealing with progress in light of the child's circumstances.
Beverly, your audio froze a little bit. Sorry to interrupt. Your audio froze a little bit. Can you repeat the last part for this slide, because your audio was frozen? I want to make sure we don't miss out.
Yeah, I'm sorry. So we're still dealing with educational benefit, but we're dealing with benefit in light of the child's circumstances due to the Andrew case. And you could skip this next slide. Skip that one and go to, So what happens, go back one. Sorry. What happens if there's a disagreement over content, goals, services, or placement? So what happens if the IEP is not complied with and services are not provided. So this is where you get to the when things fall off the shelf. What is the parent supposed to do if either they're at the IEP meeting and they don't agree with what's being proposed, or they have an IEP and somebody's not following it? And what we're seeing right now is a huge number of speech and language professionals are not available. So just about everybody in Duval County, I'm sorry, Duval County, but just about everybody in the county who has an IEP requiring speech and language, and this might be throughout the state, I'm not practicing everywhere, is they're not getting speech and language services because there's no one to provide it. So, as a related service, they need it, they're not getting it, their behaviors are getting worse, and how much of that is because they're not getting the speech and language, and it's really a problem. But they're not following the IEP because those services are not being provided. So that's an example of when it's not being complied with. When it's being disagreed over, you ask them to provide an hour of reading service because you think that's necessary, and they refuse and say, we're only providing a half an hour because we don't think he or she needs that much. So both of those things can happen. And so what do? Well, what you end up doing is figuring out how you can make the school comply, or how you can get them to increase the services that you actually want to increase. One of the means is to file a state complaint, and the next slide kind of addresses this. This is talking about what happens when the state looks it and ask for them to conduct an IEP, or you can file a complaint and they will come in and investigate and determine if you've been denied FAPE or not. You can also, and that goes back for the entire year. So, so for that year that was prior, you can recover a year's worth of services from an IEP through a complaint through the Florida Department of Ed. You can also file with the Division of Administrative Hearings. But I'm getting kind of ahead of myself because I'm worried about time. If you'll just go one slide ahead, Jorge, thank you. Every time you meet with the school regarding your child with unique needs, they will provide you with a packet. Well, sometimes I think they're emailing them now. They used to hand them out. It's like 35 pages. It's 20 U.S.C. 1415, and it's called the Procedural Safeguards to Providing FAPE. And it includes all of these things. So it outlines your right to examine the records, your child's records. It outlines the protections of a child that doesn't have a parent that's functioning, so the rights of a surrogate parent. It outlines the right to prior notice. If the school is going to make any changes to anything in that child's program, you have to have prior written notice. It outlines the notice needs to be in the child's native language. So if English is not your first language, you have to be given notice in your first language. It tracks your opportunity for mediation if you have a complaint, and how you can access mediation right out the gate if you're not happy with the way things are going. It outlines the process for a state complaint. It outlines the procedures for due process through the Division of Administrative Hearings. which is different than a state complaint because that goes back 2 years. So if you're struggling with the school and you've been struggling for more than a year, the filing with the Division of Hearings is an avenue. There are three judges, or there were three judges that dealt with educational issues only at the Division of Administrative Hearings, and they will come to your county, or you sometimes will meet them somewhere, but you can have a multi-day evidentiary trial on the issues that you've had with the school system. It outlines the stay put provision. So if your student has some sort of disciplinary issue, or there's some issue with the school, it outlines your right to stay in the current educational placement until you've had your issue heard. It outlines the right of your student to stay where they are before there's an alternative placement. It outlines when the transfer of rights occur and how that's supposed to occur. So this is a very comprehensive document. Like I said, it's probably 35 or 40 pages, and it gives you all the statutes involved in all of these areas. So it's extremely helpful for parents and for attorneys. So if you need to look things up, this is where I would start. So I think this might be near the last slide. Yeah. When things go wrong, I included the two that I mentioned, the complaint to the state. I said there was little teeth in that. There's little teeth because what happens is the state will tell you that they haven't provided you with FAPE, but then they can't force them to comply. So sometimes it's good to file a state complaint and find out that they haven't provided you with FAPE, and then you can file a due process hearing and go back 2 years if they've continued along the same path, not providing you with FAPE. There's always an option for mediation in a state complaint, the option for mediation in a due process hearing. The school board has to agree to, just like they do in the state complaint. Some school districts don't want to mediate. Due process hearings are very involved and can be very expensive. So, parents can do these on their own. The problem is that you're frequently up against another attorney from the school district who knows their stuff. And the good thing about due process hearings is that attorney's fees are statutorily provided for. So if you win, you can get fees. But it's a lot of hard work, and a lot of times there's settlement, and fees are one of those things that are not always easy to come by in settlement. Those are the high and low points. And that is kind of me rushing through educational advocacy. I know there are a number of questions. Glorian, do you want to join me and see if we can answer some of these questions?
Yeah, so
Absolutely.
we had one on the Q&A, so I'm gonna take that one off quickly. I'm gonna read it out loud. Will you be discussing the difference between IDEA's concept of intellectual disability and Florida's definition?
So I'm not aware of the difference that they're referring to.
Okay, we can follow back on that one. I'm gonna go through the chat because I see a few questions in the chat. One of them is requesting a copy of the matrix. If that's a document that can be shared, we can add a copy of the matrix to the materials.
Yeah, definitely. I will have to get it to you when I get back to the house, but I will get it to you. It's just
Okay,
a 4-page document.
okay, we have another question. May we have the name of the Gobble Cookbook? And the author again, please.
Yeah, it's Barbara D is in dog Bateman, Bateman, and she has a Ph.D. and a J.D.
Let's see. I think those were the questions that we had in the chat. So if anybody has any other questions, feel free to drop them. I did drop the link to the materials folder. You can find the slides in there, and if any other resources come up, we will drop those in there as well. And let me go ahead and drop the CLE code information as well, so everybody has it. As I said earlier, this training was approved by the bar for 1.5 general CLE and 1.5 certification credits for both education law and for health law. So the CLE code is 2504816N. I'm gonna drop it here into the chat. That code will also go out via email from Zoom. I will also include it in the description of the video. I'm gonna drop some information as well here for the next webinar, which is next Wednesday. The next webinar is the Marjory Stoneman Douglas Act, Teachers with Guns. So we're going to hold that one next Wednesday at noon. Here's the registration link for that webinar, just in case you haven't registered yet. All right, so I see a few thank yous. This was excellent from our friend and colleague Janine. Any other questions for our speakers? Let's see. We see a comment here. Thank you for this. My wife has been in public school ESE services for about 30 years, speech language pathology.
We need her.
All right. Any closing statements before we wrap up? Beverly or Glorian?
Thank you for the opportunity.
Thank you all for listening.
By the way, a lot of credit to Glorian. I think one of our first meetings, she goes, "Hey, I have this idea. I need you to meet Bev," and Bev put together this 4-part series. So we're really grateful for both Glorian and Beverly here today. We're looking forward for the next webinar. So we'll see you all next Wednesday. Thank you again, and have a great rest of your day.
Happy Juneteenth.